Hello, everyone. Hi, everyone. It is Sunday afternoon, December 21st, and welcome back to Sinister. Today, before I get started, I guess the sidebar transcripts, the first batch for trial number one, have been uh, distributed or put out there. I can't wait to see what those say. Those should be pretty interesting. I'm sure everybody's going over them. So I'll have to tune into either the Glare or Melanie or somebody to see what's going on with those. And yeah, so that was pretty fast. I'm surprised. Although I do believe that the first trial was already transcribed. So it's the second trial that hasn't been fully transcribed yet. So that one might take a while. But yeah, they're out. What else is there? I don't think there's much else to update you on. I hope everybody's ready for Christmas. Got all your Christmas shopping done in the Christmas spirit and whatnot. Um, I'm done. I just had to go out and get the final, the little things like stocking stuffers and whatever. But I did that yesterday, so I'm completely finished now. I even though I work on Christmas Eve and Christmas Day, and I work both nights, so that'll be interesting because I am off Friday. So I have agreed to cook Christmas dinner on Friday. So I won't get any sleep on Friday after working Wednesday and Thursday night, and then I don't know. I'm getting too old to do that. But I'm starting to feel it more and more and more. They say that people that work night shift die younger, and I believe it. I'm feeling close to it sometimes. Of course, this is the busiest time of the year for respiratory therapists, and that's what I am. So I'm running my butt off when I'm working. No rest for the wicked, right? So today we're going to go over ex sheriff, ex um, Letcher County Sheriff Mickey Stines, um, the civil suit that he was a defendant in, or is a defendant in, one of multiple defendants. Um, Miss Adkins has a suit against them, and I'm going to go over the motion for summary judgment in that case. It looked pretty interesting. I was looking at it last night, and so we're going to go over that if that's okay with everybody. Something a little different than what everybody else is doing today or this weekend, hopefully. So let me see. This is a pretty long document, so I hope you guys are in for the long haul, I should say. Okay, so Sabrina Adkins and Jennifer Hill are the plaintiffs. Ben Fields, individually and in his official capacity as deputy sheriff with the Letcher County Sheriff's Department. Mickey Stines, Letcher County Sheriff, and Eastern Kentucky Correctional Services Incorporated are the defendants. And this is a memorandum in support of motion for summary judgment. Comes the defendant, Ben Fields, individually by and through counsel, and for his memorandum brief in support of motion for summary judgment states as follows. 1. Introduction. On February 7th, 2025, a motion for summary judgment was filed on behalf of defendant Stines and the Letcher County Sheriff's Department. In his supporting memorandum, the Sheriff's Counsel maintains that the evidence presented during discovery does not support plaintiff's constitutional claims. He specifically contends that Deputy Fields' conduct does not rise to the level necessary to support plaintiff's claims that he violated the 4th and 14th Amendments. Defendant Fields now incorporates these well-supported arguments within his own motion for summary judgment and memorandum. On February 28, 2025, plaintiff filed a quote-unquote combined response addressing not only the issue raised by defendant Stines' motion for summary judgment, but those that might be raised by defendant Fields. Apparently recognizing the strength of defendant's arguments, plaintiff's counsel provides a very exaggerated summary of her client's allegations that is not supported by the actual evidence revealed during discovery. So they're saying that her summary of allegations does not match the evidence. Counsel first claims, quote, there are at least 3 women who were violated and sexually essayed by Deputy Fields between 2019 and 2022. 2 of whom are plaintiffs in this lawsuit, end quote. Besides Ms. Atkins' counsel claimed that Jennifer Hill was victimized by the deputy. However, Ms. Hill died before her deposition was taken, and the general allegations in her complaint have not been subject to cross-examination. Her son, Billy Dwayne Adams, serves as the administrator of her estate, but was unaware of this suit or any allegations made prior to his mother's death. She must have died pretty young. The estate instead relies upon the affidavit of Plaintiff Hill's fiance, Chris Triplett. However, the allegations made in his affidavit are not based upon personal observations. Again, details are provided, nor has he been deposed. Wouldn't that be hearsay? I guess there's different things they can do if somebody dies before the court hearings, huh? Upon reading the affidavit, it is evident that his knowledge is not based on personal observation of SA. He claims that he, quote unquote, became aware of such conduct without revealing the source of the information. It is evident that the account given in the affidavit is hearsay upon which summary judgment cannot be maintained. The quote unquote third woman is referred to only by her initials BC. Plaintiff's counsel has submitted a recorded interview of this supposed claimant in which she alleges that she was propositioned by Deputy Fields and that he made advances. Notably, the recorded interview was not taken under oath, nor was the witness subject to cross-examination. By contrast, Plaintiff Adkins has been deposed and subject to cross-examination. During her deposition, she confirmed statements made to the state police. She told investigators that she had agreed to a liaison with Deputy Fields and saw it as an opportunity to avoid payment for the home incarceration equipment, the GPS bracelet. Any stress she felt was directed more towards staying out of jail rather than any occasion from Mr. Fields, any coercion from Mr. Fields. You notice they're not calling him Officer Deputy Fields because he's lost his job. As for the criminal charges, It should be noted that Mr. Fields' guilty plea was part of a negotiated settlement reached during mediation. Also, Ms. Adkins' consent was not an issue relevant to the third-degree rape charge under KRS, and it gives us case law or statute, or the third-degree sodomy charge under statute. Rather, by statute, she was deemed to be incapable of consent when she was in Deputy Fields' custody. As set out below, however, it is a factor in determining coercion sufficient to violation of constitutional rights, both under the 4th and 14th Amendment analysis. 2. Statement of case. On January 31st, 2022, plaintiffs Sabrina Atkins and Jennifer Hill filed a complaint against defendants Ben Fields individually and in his official capacity as a deputy sheriff with the Letcher County Sheriff's Department, unknown supervisors of Ben Fields, and Mickey Stines, Letcher County Sheriff. This memorandum will address allegations brought specifically against Fields in his individual capacity. On March 16, 2022, plaintiff then filed an amended complaint. On September 28, 2022, plaintiff again filed a second amended complaint, naming Ben Fields' employer, Eastern Kentucky Correctional Services, Inc., as a defendant. Hereafter, EKCS is how they're going to refer to the correctional facility. As it relates to plaintiff Sabrina Adkins, she alleges the following in the second amended complaint. I keep wanting to say amendment. Ms. Adkins alleges that in June 2021, she was released from the Letcher County Jail and placed on home incarceration. At that point, defendant Fields, alleged to be a deputy sheriff, was assigned to be her home incarceration officer. She claims that Fields visited her the night of her release and consoled her with cigarettes. She claims she told Fields that she didn't have money to pay for her ankle bracelet, at which point defendant Fields made flirtatious comments about her looks and body and told her he was confident that they, quote unquote, could work something out. Ms. Adkins claims that she routinely communicated with Fields by text and that he arranged to meet her at the courthouse during nighttime hours for sexual encounters in Judge Mullins' chambers. Plaintiff claims that she felt compelled to comply with defendant Fields' advances as she could not afford to pay for the ankle monitor and did not want to return to jail. She claims that she did not consent to the sexual abuse. Plaintiff alleges that certain persons at the Letcher County Courthouse were notified that defendant Fields was having inappropriate relations and communications with Sabrina, and that Fields became aware of the allegations. At this point, defendant Fields stopped communicating with Sabrina by text or other messages. However, early in January 2021, she claims that Fields filed a complaint against her, asserting that she was not complying with her terms of home incarceration. Adkins claims that Fields took this action to punish Sabrina and in an attempt to save his own job and reputation. Sabrina claims that she was thereafter arrested on January 26, 2022, and taken to the Pike County Detention Center. Adkins claims that she has suffered and continues to suffer from emotional distress and suffered mental anguish. As it relates to plaintiff Ms. Hill, she alleged that she was arrested in Letcher County in 2019 and incarcerated at the Letcher County Detention Center. In August 2010, she was put on home incarceration and was to be supervised by defendant Fields. When Fields met with Jennifer to place her ankle monitor, he allegedly told her that if she could not afford to pay the home incarceration fees, that they could, quote unquote, work something out. He also allegedly told her that, quote, if she did him a favor, he would do her a favor, end quote. Thereafter, Jennifer claims that defendant Fields began asking for sex in exchange of waiver of the incarceration fees, and she declined his advances. She claims that after she declined his advances, that he created home incarceration conditions violations, which resulted in her arrest. What a piece of shit. On August 17, 2021, Jennifer was arrested, and soon thereafter, she was bonded out of jail on the conditions that she would comply with home incarceration. Within a few days, she claims that Fields showed up at her home with Sheriff Mickey Stein, claiming that she had an overdose. Jennifer claims that EMS personnel thereafter arrived at her home and threatened to give her a drug screen, and that after other emergency workers had left, that Fields again told her that she needed to succumb to his essay. She claims she involuntarily complied with Fields' instruction and engaged in sexual acts with the defendant. Now, was Mickey Stines present at that time? Because remember, it said that Mickey Stines went to her house with the defendant. Thank you, Maddie. So if they went there together, that means Mickey Stines, the sheriff, was actually there when Adkins propositioned her again. So why the hell isn't that's why Mickey Stines was brought up on charges also. It wasn't just for his lack of training the deputy, I think. The unwanted sexual abuse continued through October 2021, at which point Jennifer was incarcerated for traveling to London. Oh, London, Kentucky, to visit her newborn granddaughter. I was going to say she can't afford the home incarceration fees, but she can go to London. But never mind. She claims in the presence of Deputy Sheriff Whitaker that defendant Fields told her, quote, "Remember what I told you and keep your mouth shut," end quote. She claims that when she was arrested in October 2021, that her cell phone was confiscated and never returned to her because it had incriminating communication between herself and defendant Fields. I can't believe he's so stupid as to actually text her. According to the complaint, she was arrested in February 2022 on an arrest warrant from another county and remains housed at the Perry County Detention Center. Like Adkins, she claims to suffer emotional stress and mental anguish. Hill subsequently died, and her estate was substituted as party plaintiff. I think I said that Adkins was the other defendant. I didn't mean Adkins. I meant Fields. Sorry. So Sheriff Stines was at her house with Fields when he made that second or that following or that the last whatever, I can't even think of the word, sexual come on to her to pay for the fees of her incarceration. So Mickey Stines had to have been there with him, but it's Fields, not Adkins. Adkins is the plaintiff, so I apologize for that mix-up. Anyway, the lawsuit alleges that defendant Fields, in his individual and official capacities, violated the plaintiff's 4th and 14th Amendment rights to be free from arbitrary action, unreasonable searches and seizure, and deprivation of liberty. The plaintiffs also allege that defendant Fields is liable under state law for damages for false imprisonment, assault and battery, malicious prosecution, intentional infliction of emotional stress, negligence, and gross negligence. I don't know what the difference is between negligence and gross negligence. If anybody knows, put it in the comment, because to me, I mean, is gross like is it like what's I don't know if they mean gross as in it's gross, or gross as in mass quantity or whatever, but I don't know. They always say gross and then just the regular, and I don't know what the hell the difference is. But yeah, sounds to me like she's got a good case. What a piece of shit. The Second Amendment, I keep saying amendment. The second amended complaint alleges the following counts. Count 1, the defendant Fields violated the plaintiff's rights secured by the United States Constitution, Amendment 4. Count 2, the defendant Fields violated the plaintiff's rights secured by the United States Constitution, Amendment 14. Count 3, deliberate indifference to supervise and train pursuant to, and it gives the statute, against Letcher County Sheriff and unknown supervisors of defendant Fields. Negligence, gross negligence, assault and battery against defendant Fields. Count 5, grossly negligent intentional infliction of emotional distress. Count 6, intentional infliction of emotional distress. And count 7, negligent retention, training, supervision against defendant EKCs. She's trying to say that it is the reason why Mickey Stines was charged is because it was his responsibility to train Deputy Fields. And my question is, how do you train somebody not to do something? I mean, it's like they should know better not to sexually assault somebody. I mean, that how do you fit that into the training? That should be a no-brainer, if you ask me. But I guess he was supposed to train him not to commit sexual assault in the judge's chambers, mind you, because this is Judge Mullen's chambers where all this took place. So I say that the judge did know about it. The complaint contains a claim for punitive damages on the basis that defendant Fields' actions were malicious and intentional conduct. Well, no shit. No specific amounts for damages are listed. The complaint also makes a claim for attorney's fees. Discovery is now completed, and below is a summary of depositions taken. On or about January 19, 2023, plaintiff Jennifer Hill died. By order entered August 9, 2023, in Magoffin District Court, Jennifer Hill's son, Billy Adams, was appointed administrator of the estate of Jennifer Hill. On August 18, 2023, plaintiffs filed a motion to substitute the estate of Jennifer Hill as a party, and court subsequently granted that motion. 3, facts. Plaintiff Sabrina Adkins. This is, I believe, her deposition. At the time of her deposition, Sabrina Adkins was an inmate at the Leslie County Detention Center. Her first instance of trouble with law enforcement was in 2016 in Pike County for a DUI. Most of her charges were in Letcher County or Pike County. She was also charged with a second DUI that same year. She would later be charged with a third, Jesus Christ, a third DUI for two Norco 10s and possession in 2017. Adkins began developing an addiction to pain pills sometime around 2012 as Dr. Fannin prescribed them for her back. Isn't that what everybody goes to pain management for, is for back pain? Because they can't really disprove it, so you can get your drugs. In 2021, she would be charged with possession of meth in Letcher County and was incarcerated on this charge. She was placed on house arrest and then probation. She violated her probation by using drugs. She has been housed in jails at Letcher, Pike, Warren, Franklin, and Leslie County. In total, she has been convicted of 3 felonies. Wow, that's sad. She agreed that her allegations raised in the complaint relating to Fields began after June 2021. At the time, she was taking the following medications: Polytrim, Robaxin, Lyrica, and ibuprofen. I don't know what any of those are. She also, I think Lyrica might be a mood enhancing, like an antidepressant, but I'm not positive. She also agreed that she was actively treating for anxiety, insomnia, and bipolar disorder before April 2021 and started using meth at the approximate age of 40 years old. Why so? Oh my God. I've heard that a lot of people use meth, a lot of people with bipolar or depression or multiple personality disorder or whatever use meth. And apparently it affects them the same as their antipsychotics or their psych drugs. I'm not sure how true that is, but it seems like a lot of people that have mental psych issues are on meth. And I don't know if the psych issues are brought on by the meth use or if the meth use helps hide the psych issues. And then when they're not on the meth, the psych issues come out. I'm not sure which affects which and, which comes first, the chicken or the egg. But yeah, that's pretty late in the game to start taking something so hardcore. I wonder what made her start taking it. That's sad. She was incarcerated from April to June 2021 in Letcher County. She was then released in June 2021 and placed on home incarceration. She did not know Fields prior to June 2021. She first met Fields at the jail. She had been placed on house arrest at the jail. She had been placed on house arrest, sorry. And he put the monitoring device on her leg. Fields' wife, who was a guard at the jail, are you shitting me? So you're telling me that he's pulling this shit and his wife is a corrections officer at the jail that he's doing this at or taking the prisoners from? What a piece of shit. How did she not know? Because everybody, people talk. How did she not? She probably was in on it. Just saying. Okay. She first met Fields at the jail. She had been placed on house arrest, and he put the monitoring device on her leg. Fields' wife, who was a guard at the jail, and some other guards witnessed this take place. She did not know who the other guards were. So she was in on it? The wife? After the monitoring device was placed on her, she then notified Fields once she arrived at her house. She told Fields that she was living with her boyfriend, Stacy, who had also been arrested and was in rehab for inpatient treatment. However, Stacy called the police as he did not want Atkins to stay at his house. Well, why? You're not there. She needs a place to go. At this point, Fields helped Atkins move to 164 Perkins Branch with Dale Martin, where she stayed. Who's Dale Martin? She also stayed in Pike County for a brief period while on home incarceration. She arrived at Dale's around 1 p.m. that day upon release. Fields had consoled her because Stacy did not want her to stay at his house because she was on house arrest. According to the judge's order, she was not to leave Letcher County, but Fields allegedly did not report this. Of course not, because now she owes him something. Fields would visit her in the evenings to bring her cigarettes and console her. She needs a lot of consoling, apparently. Atkins proceeded to tell Fields that she did not have the money for her ankle bracelet. Before her bracelet was placed on her, she had to pay a monitoring fee that her sister Melissa Polly, Atkins, what? They left something out. I'm assuming that Melissa Polly paid. Atkins was terrified of the Letcher County jail because the conditions of the jail were very poor. While in jail, she made written complaints regarding her treatment as she developed a severe yeast infection and was not allowed to take a shower. She was under home incarceration supervision from June 2021 to January 2022. I'm not even going to ask. Fields would make flirtatious comments about her looks and body and told her he was confident they could work something out. In particular, he allegedly told Atkins she was pretty and she had pretty legs. She did not make any flirtatious comments towards Fields prior to his advances. After speaking with Fields, she filed motions with the court in an attempt to lower her device fee, but they all were denied. Before Fields told her they could, quote unquote, work something out in return for sexual favors, she had heard allegations that women had given him sexual favors in exchange for not having to pay for their house arrest fees. She had heard those allegations from Crystal Dishman and Amanda Stills prior to her release from jail. Fields would regularly communicate with Atkins via text. What an idiot. She texted with Fields daily for a period of 7 months while she was on home incarceration. While she was on home incarceration, she was to go in once a week and report to Fields at the courthouse to pay her fees. Huh. A month after being released, she stopped making payments to Fields. Upon being shown a series of Facebook messages, she agreed that she began exchanging Facebook messages with Fields in 2021. She agreed that some of the messages she sent to Fields were sexual. In late 2021, she alleged that Fields had asked her to meet her at the Letcher County Courthouse after dark. Upon meeting with Fields that day in Judge Mullen's chambers, she was upset and told Fields she did not know how she was going to pay for her bracelet. She also told him that she had relapsed and needed to go to rehab. Fields proceeded to remove her bracelet. Fields would then later put the bracelet back on before she went to court and then proceed to take the bracelet off after court. This occurred a total of 4 to 6 times. No one witnessed this occurrence as the courthouse was always closed. She believed that Dale might know about these instances as he would wait in the car while her bracelet was taken off. Well, wasn't there video in Judge Mullen's chambers? That's how Mickey Stines got caught. They have it on the shooting on video. From June 2021 to December 2021, as their relationship became flirtatious, she could not recall what she told Fields about his advances as she was scared at the time. She also agreed that she made flirtatious comments towards Fields during this time period. She would send pictures of herself to Fields in hopes of not having to pay her ankle bracelet fees and to flirt with Fields. After the second or third meeting at the courthouse, she alleged that Fields' behavior escalated to forceful kissing. She could not recall the date. She also alleged that while shopping at Walmart, he had told her leg was too pretty to be swollen and would visit Dale's apartment to change her bracelet. That doesn't make sense. The first time Fields kissed her was in Judge Mullen's chambers as he grabbed her and kissed her on the mouth. She did not recall whether she told him to stop or if she kissed him back. The sexual behavior escalated to oral sex in December 2021 at the courthouse in Judge Mullen's chambers. She performed oral sex on Fields on 2 occasions and engaged in sexual intercourse 1 time. Ugh. Ew. Blech. She did not believe there were any witnesses. I would hope not. She also agreed that she engaged in these behaviors voluntarily and was not held down or anything of the sort. During her meeting with Fields, he was always in his sheriff's uniform and drove a Letcher County Sheriff Department vehicle. I want to see if I can find a picture of this guy so that you guys can just see how cute he is. Oh, crap. I mean, if it's forced on you, they're never cute anyway. But I mean, this guy's just dogged ugly. Come on. Okay. Now let me see. Okay, this guy right here is Deputy Fields. Blech. Nasty. Yeah, and that's, of course, Judge Mullins, but that is just nasty. I mean, yeah, nasty. I think I threw up in my mouth. Yeah, right. Exactly. Come on. Okay, now, of course, okay, sorry. Just so you can get an idea of what we're talking about here, because this is, anyway. Where was I? She performed, okay, then she did not believe there were any witnesses. She also agreed that she engaged in these behaviors voluntarily and was not held down or anything of the sort. Okay, so we read that. Fields believed that she had to engage in these behaviors or she would go back to jail for not paying her fees. She had asked family, including her son, ex-husband Greg, and her current landlords, Greg and Gay Edmonds, to help pay her fees. During this time, Adkins would relapse and started using meth about a month after her release from jail. She was using about $50 a day for meth, and her ankle bracelet fees were $85 a week. In December 2021, Stacey Yates would begin making complaints about Fields at the courthouse to his drug court case workers, Robbie Kinzer and Holly Boggs. Yates had made this complaint about Fields as he had gotten into an argument with her. Adkins was dating Yates at the time of the incident. Adkins did not make a complaint about Fields as she was scared to go back to Letcher County Jail. Adkins did not suffer any physical injuries from her sexual interaction with Fields, such as bruising, broken bones, etc., because of Fields' alleged conduct. She agreed that her allegations relate to mental and emotional type damages. She stated that since the incident, she has been having nightmares. As a result of her damages, she has sought treatment at Mountain Comp with Rich Godman at ARC facility and King's Daughters. She was last treated with these facilities in January 2023 and last December. She mostly recently sought counseling in February 2024 at ARC. She is also not familiar with the allegations raised by Jennifer Hill against Fields. She last spoke to Fields around January 2022 when he told her that she had a warrant for escape for failing to wear her bracelet. What a piece of shit. Fields did not make any physical threats to her, but Patty Stockham, who worked for East Kentucky Correctional, the company in charge of her bracelets, told her not to speak to Fields again. She did not view this as a threat. Billy Adams, Jennifer Hill's son and administrator. Adams offered little to no information regarding allegations raised by his mother, Jennifer Hill, in her complaint. He confirmed that he is the administrator of his mother's estate. He testified that he did not have much of a relationship with his mother. In fact, he testified that he last saw her in 2020 because he did not want her lifestyle of drugs around his children. He suspected that she died of an overdose. Billy had no knowledge as to Hill's medical or counseling history. He also had no knowledge about the facts of the case or any knowledge about her incarceration. He also had no knowledge about her suspected criminal history. He would only learn about the case after Jennifer's attorney had reached out to him in the past year. He confirmed that Jennifer lost custody of him and his siblings in 2014. She would never regain custody of the children as they would live with Brian. He has not spoken to his siblings about the case and did not know most of the individuals: Johnny Perez, Betty Jo McKenzie, Ethan McKenzie, Devin McKenzie, Paula Campbell, Anthony Potter, Bert Sloan, Angie Fields, Holly Boggs, and Chris Triplett, that Jennifer disclosed to possible witnesses about the allegations raised in the complaint, including Fields, Billy Adams' deposition pages. Billy testified that he, quote unquote, had no idea about the amount of damages being sought in this case. Defendant Sean Stines. Former Sheriff Stines went to the Letcher County Sheriff's Office to work when Steve Banks was the sheriff around 2002. He worked as a court security officer, which in that position, Judge James T. Wood and County Attorney Harold Bowling, approached Stines about a job for East Kentucky Correctional Solutions. Once employed, he worked with Patty Stockham to be trained. He said he worked for EKCS for 14 to 16 years, starting in around 2004. Former Stines testified that Ben Fields was hired by Sheriff Webb, but he recommended him to Webb. Stines took state training at the sheriff's conference. He attended every year but the year of COVID. When Stines became sheriff, he left EKCS and recommended Ben Fields to Patty Stockham to be her new employer over home incarceration. He was asked about policy and procedure with regard to outside employment of Ben Fields, and he said they just had a verbal agreement. He was asked if Ben Fields was violating policy if he was wearing his deputy sheriff uniform while working for EKCS, and he stated that it was okay if he was in the courthouse. So is that why Fields took the women to Judge Mullen's chambers, because that was at the courthouse, and Stines told him that he could wear that uniform as long as he was at the courthouse? I don't know. I'm just saying. Just asking for a friend. Anyway, where was I? He was asked about using the deputy cruiser in his role as EKCS representative, and he said it was okay if he was stopping on his way home to get a monitor out of the creek or something. He was asked if he terminated Ben Fields because of his violation of the ethics policy, or quote unquote conduct unbecoming a police officer, and he reviewed Fields' termination letter, which confirmed he had. I would think that rape is unbecoming a police officer. I'm almost certain that's a violation of that policy. He denied that Chris Triplett had filed a complaint with the Sheriff's Office of SA of sexual misconduct on behalf of Ben Fields. He stated he first found out about Ben Fields' sexual misconduct by a reporter who called the sheriff's office, but was unaware of the date. Wow. Well, it was pretty well known through the county that this shit was going on. I get the feeling that everybody knew. Nobody talked about it. After he found out about the alleged misconduct from the reporter, Brianna Cornett came in to talk with him. He talked with Commonwealth Attorney Edison Banks, who advised him to open an investigation. KSP would not take the investigation, but the Attorney General's office did. Of course, KSP is not going to take it. They're involved in a lot of it. A recording was played for Brianna Cornett, where Cornett stated that her mother came twice and talked to Stines about Fields' behavior, but Stines denied ever speaking with Cornett's mother. According to Stines, Judge Kraft and Robbie Kinzer from drug court both misconduct, but did not tell him until after he had already learned about it on January 31st, 2022. He later met with Brianna Cornett the same day. She told him what had happened between her and Ben Fields. LaShawna Frazier was present at the time of this meeting. He did not record a statement or anything. He wrote down her name and number and told her he would have somebody contact her. He then created a letter of suspension for Fields. He then met with Fields the same day, gave him the suspension letter, and told him what he had learned from the reporter and Judge Kraft and Kinzer. Stines did not recall much from the meeting with Fields. So they don't fill out any kind of documentation or anything when they do stuff like that. That's crazy. I know it's a small county, but still. He called Patty Stockham on January 31st to tell her what he had learned. Stines said he apologized to her for recommending Fields. On February 2nd, he talked with Bert Sloan, who told him that whoever investigated it needed to talk to Ben's wife, who worked at the jail. He later sent in a form to the Kentucky Law Enforcement Council to notify them of Fields' suspension. He gave a termination letter to Fields on February 2nd. On February 10th, Judge Kraft contacted him and said that Brianna Cornett had informed him of more information about Fields. Defendant Benjamin Charles Fields. Ben met Mickey Stines when Stines was a bailiff and Ben worked at the jail. They developed a friendship, and Ben would often go to Stines' house for poker parties. Stines later approached Ben about a job if he won the election of sheriff. When he did win, Ben went to work for him in 2019. Stines later got him the job at the East Kentucky Correction Solutions. In 2019, he shadowed Stines to learn how to do that job. He knew both Judge Mullins and Judge Kraft in their capacity as judge, but not outside the courtroom. Ben Fields only worked with Patty Stockham at EKCS. She trained him on how to do the ankle monitoring. He interacted with pretrial sentences in his capacity at EKCS. Part of his job with the sheriff's office was to transport prisoners. He had a sheriff's uniform, a badge, and a gun. He was working for EKCS while he was a bailiff, and he said that he sometimes hooked inmates up on home incarceration on his lunch or on days there was no court. He was paid half of the hookup fee for anybody he hooked up and $2 per day per person monitored. Wow. It was noted in this deposition by text references that Patty Stockham looked to Ben to help with decisions about bond conditions. He stated this was because he knew their bond conditions better and had access to the judge to ask if an inmate would be allowed to do something. If he wasn't present with the judge, he would text and ask permission. The judge told him he had authority to make decisions on behalf of some people. Sometimes he would get warrants on those who had violated home incarceration. He stated that sometimes those on house arrest would leave their home incarceration fees with the deputy jailers. He was asked about policies with the sheriff's office about conduct on and off duty, being beyond reproach and using their departmental position for gains, and if he violated those policies, in which he stated he was not sure. He was asked if he was terminated, but he stated again he was not sure if it was for violating these policies. There were numerous questions about sexual misconduct, and he answered that he wasn't sure or didn't remember to a lot of them. He testified that he had never had sexual contact with anyone that he arrested as a deputy, and that arrest powers his was only inside the courthouse. So he was only allowed to arrest people in the courthouse. Is that what that means? He admitted to having sexual contact with Sabrina Atkins, but he denied having any sexual contact with Brianna Cornett or Jennifer Hill. He was asked about secondary employment and the policy with the sheriff's office, and if home incarceration was a type of law enforcement work. He didn't agree that it was. Opposing counsel made a reference to ankle monitors being called Ben bands, but he stated he never referred to them as that. He was asked if he had sexual contact with a number of women, specifically by name, and he stated that he did not to all of them. He did admit to having flirtatious conversations with Brianna Cornett, but denied kissing her in his cruiser, although he also admitted to picking her up at her mother's and taking her to jail because she had violated her home incarceration. He admitted to going to Jennifer Hill's residence when there was a call that she was lying in the road overdosed, but he was in his truck, not his police cruiser. He denied having any sexual conduct with Jennifer Hill and denied going to her house again and making her get inside the vehicle. When about her release from jail and whether her cell phone was returned to her, he had no knowledge. He spoke of the time when he first met Sabrina Atkins and when he hooked her up on home incarceration. Her boyfriend, Stacey Yates, called and told him she wasn't allowed to stay at that residence. So he and another deputy, Jason Eccles, went to the residence and gave her a ride to another residence. He felt sorry for her at one point and unhooked her ankle bracelet, he said, so she could go to rehab. He lied to Patty Stockham and told her that Sabrina was taken off house arrest. He stated he only told Patty Stockham twice that people were off home incarceration when they weren't. Sabrina Atkins and Brianna Cornett. So this guy is a deputy sheriff, and he can discontinue a person's house arrest I thought that was up to the judge. Doesn't the judge decide how long somebody's on home incarceration? How is this guy able to make that decision? But they gave him a lot of control over these people. It's crazy. But not all of them, just women, apparently. Wow. Okay. He admitted to having sexual contact with Sabrina in the bathroom by the judge's secretary's office, not in the judge's chambers. He stated he was in the bathroom once with her. He stated he hugged her another time and that they were in the courthouse after hours several times. He stated that he didn't recall telling her that he could help her with her fees. He also didn't recall telling her that his uncle could help her with criminal charges. Well, who's his uncle? Opposing counsel brought up that Stacey Yates had gotten an EPO against Sabrina Atkins and Judge Kraft. And Judge Kraft asked Ben to look and see if she had left her house, and if so, to get a warrant for escape. But he couldn't because he had left her off house arrest. He stated he thought he told that judge that her GPS was messed up and he couldn't get any information on it. He stated that he did not know that Stacey Yates had a relationship with Brianna Cornett. So Stacey Yates had a relationship with Brianna and Atkins? Sabrina Atkins? Another situation like the Rebecca Park case where everybody's screwing everybody and everybody's related to everybody and everybody's having everybody's baby. I mean, that case is a total shit show. And it sounds like this one's a total shit show too. I guess in these small counties and whatever, there's nothing else to do but sleep with each other and fornicate and have babies and whatever. So everybody sleeps with everybody and fuck it. We'll worry about it all later. We'll worry about what comes out in the wash later. Fucking unreal. Opposing counsel, wait, did I already read that part? Okay, yeah. He was also unaware that Stacey Yates had reported his relationship with Sabrina to Robbie Kinzer in drug court. He stated he finally did swear out a warrant because Sabrina was supposed to come in. She was later arrested on escape for the warrant he swore out. Mickey Stines was the first person to contact him and tell him of a lawsuit and that it was in the news. He stated he and Stines had a talk in Stines' office on January 31st, 2022, and that Stines asked Ben if it was true, and Ben told him no. During that meeting, Ben turned in his badge and gun. Stines later gave him a letter on February 2nd terminating his employment. He called Patty Stockham at some point between January 31st and February 2nd and told her what was going on. She terminated his employment as well. He pled guilty to degree sodomy, tampering with prisoner monitoring devices, and perjury second degree. He stated that he has not spoken to Mickey Stines about the case. Patty Stockham. When her husband was diagnosed with leukemia, Patty became president of EKCS. At the time she became president, Mickey Stines was an independent contractor. He worked in Letcher County for EKCS for around 20 years. Mickey Stines was recommended to Patty by Judge Woods. He worked at the jail at the same time he worked for EKCS. He left EKCS when he ran for sheriff at the end of 2018. Oddly enough, EKCS is not insured and has never been. It does not own any real property. Their workers are all independent contractors who file LLC paperwork, and their checks are made out to the LLC. Ben Fields was an independent contractor who was recommended by Mickey Stines, who also worked at the jail with Mr. Stines, Patty Stockham. Who also worked at the jail with Mickey Stines. Mrs. Stockham did not seem concerned with paperwork. She did not give any directions to her workers on how to keep files or what they did with them. EKCS did not provide training on sexual harassment or sexual assault. There were no policies when supervising family members or close family friends. There were no uniforms for EKCS workers to wear. There was no paid mileage for travel. Ms. Stockham did the training for the workers herself. The software she used had online training, which she would watch. Others did not have access to the program. Independent contractors received $25 per hookup and $3 per day that person was home incarceration. Well, that's more than what they said Fields was getting, right? Workers had receipt books and gave written receipts to those who paid their home incarceration fees. Mrs. Stockham said folks usually always paid, but if they didn't, they would usually let them wait until the next week. Plaintiff's counsel had a copy of the contract signed by inmates when they went on home incarceration. He went over that with Mrs. Stockham. She advised that they agreed to follow the court order, which controlled. According to Mrs. Stockham, if a supervisee just got out of range, it wasn't a violation. She said they rarely had an escape violation, maybe twice a year in Letcher County. Where they did, she would send to her representative, and they would go to the judge and get a warrant for the escape. Any violations, according to Mrs. Stockham, were reported to her representative, and they would notify the judge. She never got confirmations that any of that was provided to the court. She trusted her representatives. Wow. So there's no paperwork at all on any of this shit. If clients did not charge the unit and it went dead, that could lead to a violation. So if they went out of range for the GPS, that's not a violation. But if they forgot to charge it, that's a violation. It's kind of backwards. If supervisors had a problem and needed to leave the home in which they were living, if supervisees had a problem and needed to leave the home in which they were living, they were to call Mrs. Stockham. She stated she assumed if there was a problem with her contractors that the inmates would have spoken to her. When pressed with records for Sabrina Adkins, Mrs. Stockham stated that Ben would tell her the judge gave her permission to do things, and she would make a note of it. If there was a violation, sometimes Mrs. Stockham would call the supervisee first to see what was going on, then check with Ben to see if they had permission. If they didn't, then she would give him the printout to give to the court for a warrant. According to Mrs. Stockham, Ben had told her that Miss Adkins had permission to go stay in Pike County with her ex-husband and son from time to time to care for her ex-husband who was ill. She said she followed up with the judge and he had given her permission to go. Okay, just 1 second. I need a drink. My husband and I went out to lunch today, and I had a beer or two, and now I have cotton mouth. But we had to go to our favorite restaurant at least once before Christmas. I haven't been in forever. Apparently, he's been quite a few times in the last week or so, but I haven't been in a while. But it was good. I love it. Anyway, let's go back. Mrs. Stockham learned later that Sabrina Adkins was not taken off of home incarceration like she thought on August 2nd, 2021. She found out after she fired Ben and talked to the investigator. She did not know about the charges against Rob until Mickey Stines called her, after which she called Ben and fired him. Get the fuck out, is what she said. When asked about Jennifer Hill's violations, she said the same thing she had about Mrs. Adkins' violations, that some of them were not truly violations. However, on one occasion, according to Miss Stockham, Miss Hill had cut her strap on her ankle bracelet. That's a violation. A summary judgment standard. A court, quote, shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law, end quote. A reviewing court must construe the evidence and draw all reasonable inferences from the underlying facts in favor of the non-moving party. Additionally, the court may not, quote unquote, weigh the evidence and determine the truth of the matter at the summary judgment stage. The burden of establishing the absence of a genuine dispute of material fact initially rests with the moving party, requiring the moving party to set forth, quote, the basis for its motion and identify those portions of the pleadings, depositions, answers to interrogatories, and admissions on file, together with affidavits, if any, which it believes demonstrate an absence of genuine issue of material fact, end quote. That was a long fucking sentence. It kills me how you get docked for writing run-on sentences in high school, and then you can write a 2-paragraph sentence in law school or in the court system, and it's okay. The party moving for summary judgment bears the initial burden of showing that there is no material issue in dispute. If the moving party meets its burden, the burden then shifts to the non-moving party to produce, quote unquote, specific facts showing a genuine issue for trial. However, rule mandates the entry of summary judgment against a party who fails to make a showing sufficient to establish the existence of an element essential to the party's case and on which that party will hear the burden of proof at trial. Let me read that back again real fast in my head. The absence of a genuine dispute of material fact initially rests with the moving party. Party to set forth the basis for its motion. Okay, that's confusing. A fact is material if the underlying substantive law identifies the fact as critical. Only disputes over facts that might affect the outcome of the suit under the governing law will properly preclude the entry of summary judgment. Factual disputes that are irrelevant or unnecessary will not be counted. A genuine issue exists if there is sufficient evidence favoring the non-moving party for a jury to return a verdict for that party. Where the record taken as a whole could not lead a rational trier of fact to find the non-moving party, there is no genuine issue for trial. Such evidence must be suitable for admission into evidence at trial. Plaintiff's Fourth Amendment individual capacity claims against Fields under Count 1 must fail. In Count 1, plaintiff alleges that Fields' knowing and reckless sexual abuse of the plaintiffs constituted a violation of the plaintiff's right to be free from unreasonable search and seizure secured by the United States Constitution Amendment 4, which is actionable pursuant to this statute. The two primary sources of constitutional protection against physically abusive governmental conduct are the Fourth and Eighth Amendments. The Fourth Amendment's prohibition against unreasonable seizures of the person applies to excessive force claims that arise in the context of an arrest or investigatory stop of a free citizen, while the Eighth Amendment's ban on cruel and unusual punishment applies to excessive force claims brought by convicted criminals serving their sentences. When neither the Fourth nor the Eighth Amendment serves to protect citizens, courts have applied the 14th Amendment. Here, plaintiffs appear to have been pretrial detainees at the time of their home incarceration. A pretrial detainee's Fourth Amendment rights consist of an objective and subjective component. In failure to protect cases, the plaintiff must demonstrate exposure to a substantial risk of serious harm in order to satisfy the objective element. With respect to conditions of confinement, the plaintiff must show that the alleged deprivation is sufficiently serious and that the official's act or omission resulted in the denial of the minimal civilized measures of life's necessities. To satisfy the subjective prong, a plaintiff claiming a violation of her right to protection or humane conditions of confinement must prove that the defendant knew of and disregarded, quote, an excessive risk to inmate health or safety. The official must both be aware of facts from which the inference could be drawn that a substantial risk of harm exists, and he must also draw the inference, end quote. The same standard applies to analogous claims arising under the Eighth Amendment. Let's see. Okay. Now, where was I? Here, plaintiffs appear to have been. Wait, did I read that? Yeah, I read that. The Sixth Circuit, as well as other courts, has held that uncoerced, voluntary, consensual sex cannot form the basis for an Eighth Amendment claim. Consensual sexual interaction between a correction officer and an inmate, although unquestionably inappropriate, do not violate Eighth Amendment. Well, I mean, how many women are going to say no out of fear for retaliation? Consensual sex did not cause an objectively serious injury to the plaintiff. Consensual sex between two adults does not constitute cruel and unusual punishment simply because it occurs within the walls of a prison. Moreover, the fact that a prisoner may lack legal capacity to consent in the context of criminal liability does not mean that an inmate can avoid the consequences of consent in a civil suit. Rejecting argument. Quote, that just because for criminal prosecution purposes an inmate is considered incapable of providing consent, end quote, consensual sexual relationship violated inmates' constitutional rights. Moreover, the Sixth Circuit has held that, quote, isolated, brief, and not severe, end quote, instances of sexual harassment without more do not give rise to Eighth Amendment violations. Finding that harassing comments, even coupled with one minor instance of sexualized touching during a search, fall short of an Eighth and 14th Amendment violation. Wow. That's pretty shitty. Here, plaintiffs have failed to show a substantial risk of serious harm in order to satisfy the objective element of their count one claim. It is not credibly disputed that Adkins consented to the sexual encounter with Fields and admitted that her text messages in exchange with Fields were flirtatious in nature and sent him flirtatious photographs. Adkins testified that she heard through other inmates at the jail that Fields would exchange sexual favors in return to letting females get out on home release and off their ankle bracelet, eventually prompting her sexual flirtations with him. It has also been established by Adkins that she started using meth around 40 years old, and Adkins herself testified that she was using around $50 a day on meth, while her ankle bracelet fees were $85 a week. Despite Adkins' testimony, she was scared to go back to jail if she did not condone the sexual behavior, as she could not have paid her fees. The $350 a week she was spending on meth. I thought it was only $50 a day. $350 a week she was spending on meth would have easily covered the monitoring fees. Furthermore, sexual encounters by the parties involved were brief and isolated, taken occurring over a span of months and not severe in nature, as Adkins testified that she was not held down against her will and participated in the actions. So just because she wasn't held down against her will, that they weren't bad. I mean, if they weren't wanted, if there were unwanted sexual advances, then it's all bad. They're like playing it down. As for Hill, Fields has denied any wrongdoing, let alone sexual encounters with her. Thus, the objective element has not been met by the plaintiffs, and count one claims against Fields in his individual capacity must fail. As referred to below, later in this memorandum by Chris Triplett's statement regarding Hill's knowledge, these claims are time barred. So that's a lot to digest at one time. So I am going to stop there, and we will pick up and read the second half either later on tonight or tomorrow, because my mind is numb now. And when my mind goes numb, I can't talk, and then my reading is jacked up beyond reprieve. So I probably will just record the second half and post it rather than go live. So just check back with my channel, and it should be live either tonight or tomorrow morning. I mean, not live, it should be posted or uploaded by tonight or tomorrow morning. Yeah. So I want to thank everybody for joining me or watching this. Be sure to like and subscribe. I'm trying to improve my public presentation. I'm doing a little better, but I still have a lot of work to do. And I appreciate everybody being patient with me on this learning process. And I hope you continue to join me on my venture to being a legitimate YouTube channel. So until I see you guys again, take care, stay warm, stay happy, get your Christmas shopping done. Bye.